Good morning, everyone. It's great to have you along today. Welcome to the first in a series of webinars from THSP. This one's called Fireworks in the Office, aka how to prevent a difficult situation turning into an explosive mess. We're probably going to run for about half an hour. I'm going to kick things off and then you'll hear from Andrew, who I'll introduce in a moment. And then at the end, we'll have time for some Q&A. Let me start by introducing myself. I'm Adrian Massey, the Managing Director of THSP Risk Management. Before we start, I just want to share a little story with you, something that happened to me. Quite a number of years ago, when I was fairly new to this whole management business, I had an employee who I wanted out. Basically, they came in late, they spent half the morning chatting, and they just didn't cut it. But I liked the person, so I didn't want to tell them that they are no good at their job because that might have made them unhappy. So I decided to make their job redundant. Trouble was, I had no idea what I was doing. So one day I just asked the employee to come into my office and I said I didn't have enough work for them, so I was making them redundant. Well, they were still unhappy and away they went. About a week later, the solicitor's letter landed on my desk saying that I hadn't followed procedure and they were taking us to a tribunal. I think they called it an industrial tribunal in those days. I was furious, absolutely furious. You know, how dare they? Hadn't I been kind enough to tell them they weren't good at their job and to leave them with some dignity? Apparently not. We settled out of court, but that hurt. We're getting calls every day from customers who are going through the same experience. So how do you stop it happening? There's a clue in that sentence. The essence of the message is stop. Yeah, that's it, just stop. Take a breath and think. I'll shortly hand you over to my colleague, Andrew Wilson. Andrew's my co-director and he heads up our employment law department. Andrew's an employment lawyer with 10 years experience at THSP. Prior to that, he was in the construction industry as he started work as a quantity surveyor. So he does know a bit about the businesses that most of you are in. Andrew's going to run you through some of the procedures for managing those awkward moments when you just feel like ripping someone's head off, but you've got to stop. I'll let him tell you what happens next. Thanks, Andrew. Over to you.
Thanks, Aid, particularly for sharing those experiences that everyone in management goes through. I know I've been there. We've all had those situations where an employee is giving you a headache and you wonder what you can do. Here is an example of the type of emails that I get on a daily basis from our customers. Does it sound familiar? Can you draft a letter for me, please? Member of staff requesting holidays, which we denied, then didn't come to work on those days. I had a recent case where somebody said, oh, did you enjoy your time at Legoland Windsor? How did you know? Well, you put it all over Facebook. Require a written warning to be given as his attitude around this is also poor. Lots of sick days. I'm sure all of this sounds very familiar to you. This is where it all starts to go wrong. If we are looking at situations here about where to go, all I can say is stop. You've got a problem. You may need to think about suspending the person for work at this stage and think about how serious the allegations against them are. I had a case not too long ago where someone assaulted a colleague with a hammer. Yes, a hammer. That was serious enough to suspend them from work because of the risk to others. Take some time at this point to think about the situation. Once you get an appreciation of what's happened, then you need to decide whether it's now reasonable to suspend them on full pay or to keep them at work while the investigation continues. Suspension should only be considered in the most serious of cases where there is an ongoing risk to people or your business. To suspend somebody for stealing a few paper clips, as opposed to the consideration of this issue where somebody was assaulted with a hammer, is so vastly different. And you must consider those consequences and the issues that you're dealing with. It can be tricky and needs to be handled with extreme care, as it can influence the rest of the process. In such circumstances, as a minimum, the ACAS code of practice should be followed. Some companies do have more complex processes, but I know our clients have in their disciplinary policies a set of rules, procedures, and steps that they will take when a disciplinary issue arises. And the ACAS code is as good as any. It's recognised in tribunal. But if you don't follow the code, you could have a claim brought against you for an automatic unfair dismissal. What does this mean? Well, a summary judgment from the employment tribunal judge and a 25% increase on that award that the judge has made that will be applied. So what is the average claim for an unfair dismissal in the employment tribunal currently? Well, it's £11,000. But it's not just about the award, it's also about the time, the stress, the anxiety, as well as the legal costs that this could add to each claim. So it's best, as those who have been in tribunal claims can recall, to do everything you can to make sure you have a fighting chance at the very least. Follow the ACAS code carefully and ensure you can demonstrate that you have, in case a claim is made. I often get asked, can't we just sack them? But once we have taken some time to understand the circumstances for each employee, it becomes clear as to why we need to follow the code. So now I'm going to take you through the 5 steps of running a disciplinary hearing properly. Allegations are going to be made. These are not necessarily the facts, as they could be personal opinions. But remember that age-old saying, innocent until proven guilty. This principle must be brought through must be adopted throughout. But before you start, you need to decide who is going to be involved. To run a fair process, you ideally need 3 people. 1 to investigate, 1 to carry out the meeting, 1 for the accused to appeal to after the decision has been made. In some cases, this will not be possible, but fairness still needs to be maintained. Think about this as an aid memoir: appeal, investigator, disciplinary. Appoint someone for the appeal, appoint someone to investigate the matter, and appoint someone to carry out the disciplinary meeting. 3 people, and guess what? 1 of these may be you. I would always recommend you start with appointing the last one required first, the appeals officer. This person is then completely left out of any discussions or investigations on the matter. They don't need to know anything. So when they have to decide if the process has been carried out in a fair way, they are not influenced by their own opinions or those of others, and they must be in a position to overturn the decision that you or somebody has made. All you need to do is tell them that, for instance, Johnny's been accused of misconduct and we're running an investigation that may lead to a disciplinary. Ask them if they would be okay to take the appeal if one is brought. But keep it all very simple. Now you've got your appeals officer, let's go back to the second person. The investigator must be completely impartial to the alleged offence. They can't be involved already. It's not their job to judge, but to investigate. They have to find out as much as they can about what has been happening or what has happened. They must not be involved in any further disciplinary action. The investigator is not going to be the person that conducts the meeting. Where they can, they must collate all evidence. This may be electronic or written documents, statements from witnesses, CCTV or other records, so long as they're legal, or a statement from the accused. This investigating officer must present all of this evidence to the nominated disciplinary officer, and this evidence must be made available to the accused employee if disciplinary action is considered. You send it all with the invitation to a meeting. So now we need the third person, the disciplinary officer. It is for this person to consider three things: the grounds of the investigation, the alleged conduct, and what future actions are to be taken. If they think there has been a breach of company policy, then a disciplinary hearing may follow. So when you've got your ducks in a row, you've appointed your three people, the investigator has done their job, and you've decided after you've weighed it all up that you're ready to invite the accused person to a disciplinary hearing. Are you ready? So the invitation needs to be done in writing. It can be in a letter or an email, but do not send a text. You have to be able to trace this to ensure that they've received it. In your letter, you must tell them what they've been accused of. This letter can be posted by recorded and standard post, or it can be emailed or hand delivered if they are still at work. Once you've told them why they are being invited, there are three more important points. Tell them what they're accused of and what sanctions these offences can carry. You have to share any evidence, including witness statements, at this meeting. So make sure the people who have written the statements know you'll be sharing it with the accused. Include the date, time, and location of the meeting, and confirm who will be attending as the disciplinary manager and the note taker and anyone else who may be present. It may be prudent at that time to also have witnesses available. Make it very clear that they have the right to be accompanied at this meeting, and usually by a work colleague or perhaps a trade union representative or someone else. You just don't want to end up with a smart-ass lawyer calling the shots. They will just make it very difficult for you, and they don't have a legal right to attend. At the meeting, introduce those persons present and clarify the role each has to play. For instance, the chair of the meeting, the note taker, and the companion. The meeting can be recorded, but that has to be with everyone's agreement. Make it clear that the companion can confer with the employee or ask for clarity on something that has been said, but they cannot ask or answer questions on behalf of the employee. It is the employee's job to do this. Set out for the reasons for the meeting, the allegations and possible sanctions, as stated in the invite letter. Ensure the employee has received everything and read through all supporting documentation. Talk through the matter and listen to the responses of the employee. This meeting is their chance to offer their side of what they've been accused of and to offer any explanation as to why they may have been wrongly accused. For example, you were seen taking money out of a till on Saturday, and their response may be, well, I couldn't have been because I was at the rugby. That would deem reasonable mitigation, accusing of a wrong allegation. You must not bring up any further information that hasn't already been shared. Just listen to the employee. If anything is raised that cannot be proven or requires further investigation, then just stop the meeting and agree another time to reconvene. Don't make any decisions in the meeting. When you finish discussing everything, ask everyone around the table if they have anything else they would wish to add. Once this has been done, end the meeting and tell the employee that they will have your decision in writing within the next 72 hours. Once you're happy that all the possible time and effort has gone into dealing with questions arising from the meeting, then gather your thoughts. Think objectively about the allegations, the evidence that's been collected, responses from the employee, and options that are available to you. It's not only important to demonstrate a fair process, but the decision taken must also be reasonable. Emotions need to be put to one side, and past case law can often dictate what sanctions can be taken. It's really good to speak to us at this time, even if we've not been involved in the process up to date. When you're ready to inform the accused of the outcome, it needs to be put in writing. The outcome could be anything from no action through to summary dismissal, with the first and final written warning in between. State your reasons for coming to your decision in the letter. Also provide a copy of the minutes, notes, or recording from the meeting. It's not necessary for you to be drawn into debate about the minutes or your decision, but you should set out clearly in this letter the steps the employee can take to appeal against your decision and who that appeal should be made to. This takes us on to the next stage. But before we go there are three things to remember. Tell the employee of your decision and why. Provide notes and a recording of the meeting, and tell them who to appeal to. At this final stage, the employee has the right to appeal against the decision. You've given them the timeframes, format, and the person to contact for the appeal in the outcome letter. The person you've agreed to act as the appeal manager must have the power to overturn any previous decisions. The appeal manager must not have been involved in at any stage so far. They have to then independently review all the steps that have been taken, the information that's been relied upon by the person making the decision, and the sanctions that have been given in terms of disciplinary action. So they need to fully understand the process as well. The appeal manager will then go through the same process of setting up a meeting with the employee and their trade union representative or work colleague, should they wish, to discuss the grounds of their appeal. Any further investigations must then follow, and the appeal manager then draws their own conclusions on the process and if the decision made was reasonable. The outcome is put in writing from the appeal manager, and their decision is final. So, thank you. This will hopefully diffuse any stray rockets, bangers, or sparklers that have gone off in your office recently, or may do in the future. You know where we are if you want expert help. Remember, there are significant savings to be made in seeking help first, rather than getting tied up in tribunal claims. So, let's have a look to see if any questions have been raised. Okay. So Sue has asked, in a small company, it may be difficult to have separate people in all cases and cannot take from disciplinary and appeal. So in certain situations, there may not be enough people available to hear the appeal as well as investigate and conduct the disciplinary. The law recognises this, but all reasonable steps to maintain a fair process and reasonable steps taken need to be considered. For summary dismissal, should this be in writing or verbally? Again, summary dismissals must follow the ACAS code and everything must be made in writing. Thank you, Sue. Lauren raised a question, what if mental health issues are involved? I believe in these situations and in the investigation needs to consider if the health of the individual has attributed to the conduct that has been alleged. So questions need to be asked during the investigation to see if their health has been a contribution to the alleged offence. Nigel asked the question, the appeal, must the individual set out the grounds of their appeal? Yes, the appeal is not just an opportunity for them to bemoan the situation. They must put out their reasons and grounds for the appeal. Mark asked the question, if an appeal process was not carried out, what issues does this bring for future disciplinary meetings? Well, the stages that we've discussed, 1 to 5, all of them need to be fulfilled. All of the steps within each stage need to be demonstrated. So if the appeal process has not been carried out, it's not been offered, or the hearing has not been held, then it will undo all the good work that has gone before it. That means that this warning cannot be relied upon if further action is to be taken. And if the person was dismissed, then it could lead to a summary judgment because of a failure to comply with the ACAS Code of Practice. Stephen asks, how long should the record be kept on file? It's down to the allegations, really, of what they've been adjudged to have conducted. But anything between 6 and 12 months is deemed reasonable. Anything more than 12 months would not be relied upon and needs to be removed from their personnel records. And finally, Joanne raises the question, what if the individual fails to state a reason for an appeal? Well, firstly, as I said in the first question, it needs to be interrogated. They need to set out their grounds for their appeal. If they don't have any grounds, then the appeal manager can quickly conclude that the appeal has no founding, it has no grounds for appeal, and therefore the decision remains. Thank you, everyone. That concludes all the conversations, all the questions. Aid, I think over to you. Anybody else got anything to ask?
No? Okay. Thank you very much, Andrew. That was brilliant. I'd like to thank everyone for coming. I hope you'll go away ready to diffuse any fireworks that start or that occur in your office and save yourself a lot of anguish when things go wrong. Remember what Andrew said about asking for help when you need it, particularly around things like the decision when it comes to previous case law, having set the levels for sanctions. You don't really want to go outside of what is reasonable or basically you're setting those within your own business as well. So seek advice. For those of you who don't have THSP's number on speed dial, I'd like to invite you to have an exploratory chat to discuss any matters that may be giving you grief. Send me a private chat if you'd like to talk more about this with Andrew, or just express your interest and Andrew will give you a call. So I'd like to wrap up by thanking Andrew for his presentation. Well done, mate. Very good. And Emma for co-hosting, and thank you all for being a great audience. So look out for our next webinar. We're entitling it Helicopters in the Office, aka Banter and Harassment. Thank you, everyone. We look forward to seeing you again. Bye for now.